4 young lives ended on November 13, 2022, inside a quiet rental home on King Road in Moscow, Idaho. The crime shocked the nation, not because brutal murders were new, but because this one made no sense, no motive, no warning, no survivor testimony. Just 4 University of Idaho students, Kaylee Goncalves, Madison Mogan, Zana Kernodle, and Ethan Chapin, killed with a single-edged knife sometime between 4 and 4:25 a.m. The house didn't catch fire. No windows shattered. No neighbors woke up. The killer walked in and out like a shadow. Months later, on December 30, 2022, police arrested Bryan Kohberger, a 28-year-old criminology PhD student from Washington State University. He lived just 10 miles from the crime scene, drove a white Hyundai Elantra similar to one caught on camera, and, according to investigators, left behind DNA on a knife sheath found beside Madison Mogan. To the public, it looked like a clean win for the prosecution. But courtroom reality, slow, technical, and uncomfortably strategic, rarely looks like the headlines. And in late 2024 and early 2025, the defense began shifting gears in ways no one expected. Today's hearing, a new twist so sharp it sliced straight into the heart of the state's case. And it all began with a single word: contamination. The courtroom in Latah County, Idaho was tense during the latest hearings, stretching into early 2025 as delays, pretrial motions, and expert arguments stacked like bricks. Every seat filled, every camera humming, because everyone knew Bryan Kohberger's defense team, led by Ann Taylor, had been promising something big. It arrived in the form of an accusation that the DNA evidence the state built its case on, the sheath buckle sample with a 99.9998% probability of match, might not be as unshakable as the public believed. In the new filing and in oral arguments, the defense argued that the DNA chain of custody was riddled with weaknesses. They pointed out that the sheath, recovered from Madison's bed, moved through multiple hands before ever reaching the lab. They highlighted the fact that Idaho investigators originally didn't detect Kohberger's DNA, only a partial unknown profile, and that the definitive match came later from a higher sensitivity test. And so, the defense asked, if it required such sensitive testing, could contamination be possible? Prosecutors were visibly irritated. They insisted the testing was routine, valid, and scientifically sound. They reminded the court that the sheath DNA survived multiple challenges because it wasn't hypothetical, it was specific, measurable, and confirmed through independent examination. But the defense didn't stop there. They dropped a second surprise: a challenge to the FBI's use of investigative genetic genealogy, the same technique used to identify the Golden State Killer. The defense has long claimed that the FBI used a private genealogy database without proper warrants. The prosecution counters that genealogical work didn't generate the evidence, it only narrowed possibilities, and that the final DNA link was obtained legally from Kohberger's family trash. Still, the Judge John Judge, has entertained these arguments because the constitutional stakes are high. If law enforcement crossed a line, even unintentionally, it could ripple across every case using genetic genealogy, and the defense knows that if they can destabilize the DNA, they don't just weaken the state's case, they vaporize its backbone. Prosecutors say Kohberger's phone was near the victim's house around 9 a.m. on November 13th, returning to the crime scene area after the murders. They also say the phone was turned off between roughly 2:47 a.m. The defense's counter-argument: that cell tower coverage in rural Idaho is too broad to pinpoint exact location. They claim someone driving on a nearby road could appear to be near the house even if they never approached it. They say the phone being off could indicate sleep, poor signal, or a desire for privacy, not murder. But then came the fourth twist, one that changed the tone in the courtroom: a new expert witness. Kohberger's team introduced a fresh forensic consultant who argued that the statistical interpretation of the sheath DNA might be overstated. Prosecutors snapped back, saying the defense was trying to manufacture doubt where none actually existed. The tension in the room became so thick that even seasoned reporters whispered about how different the courtroom felt. This wasn't a minor procedural hearing anymore. It had the energy of pre-war positioning, and yet, the shock of the day came in the final 15 minutes. The defense motioned to delay trial once again, arguing that new evidence disclosures had arrived too late, too complex, or too incomplete for them to properly analyze before trial. They argued that their experts needed more time to review lab procedures, genetic genealogy notes, and the FBI's case logs. The prosecution pushed back, frustrated, reminding the judge that families of the victims had already endured over 2 years of waiting. The trial has been delayed multiple times, first in 2023, then 2024, and now with the possibility of stretching into late 2025 if new motions are granted. But Judge John Judge has repeatedly emphasized one thing. This case must be fair, not fast, and so he took the motion under advisement. Outside the courtroom, whispers spread about something quieter, but equally important, Kohberger's demeanor. Throughout the hearing, he sat still, stone quiet, expression unreadable. No emotion when DNA arguments were presented, none when the victims' families glanced his way. No reaction when the defense mentioned contamination or genealogy. Just the same rigid posture and forward stare reporters noted since his first appearance in January 2023. Some reporters say he looks confident, others say detached, many say unnervingly calm, but there's one thing everyone agrees on. He is very aware that the defense is slowly reconstructing the battlefield. In the court of public opinion, most people assume he's guilty. In the court of law, the defense only needs to win one thing: reasonable doubt. And today's motion introduced enough of it that legal analysts immediately went online calling this hearing a turning point, because cases built on physical evidence can survive messy narratives, but cases built on fragile narratives can crumble under messy evidence. And then, there's the lingering question, the one few want to ask out loud. What if the defense is right? Not about innocence, but about procedure. What if the testing wasn't handled perfectly? What if one step in the chain of custody wasn't airtight? What if one clerical detail becomes the wedge the defense drives into the spine of the prosecution's case? High-profile trials have collapsed before over weaker issues. The O.J. Simpson trial, the Casey Anthony case, the Adnan Syed case. Evidence handling, lab analysis, or police protocol can shift the entire weight of justice. And that's why this hearing, technical, dense, slow as molasses, may be the most important one yet, not because it proves innocence, not because it proves guilt, but because it defines the rules of the battlefield on which guilt or innocence will be decided. As the bailiff called the courtroom to a close, families of the victims stepped out, quiet, heavy, carrying a sadness that has not softened since November 2022. They have sat through evidence photos, reconstructions, and still they wait for justice. Kohberger was let out moments later, escorted by deputies, eyes forward, jaw tight. And in the hallway, legal analysts whispered the same thing. This case is far from over, because what happened today wasn't a verdict, it wasn't a bombshell confession, it wasn't even a ruling. If this deep dive into the Idaho murders hearing kept you locked in, tap like so it reaches more viewers, hit subscribe for more high-voltage true crime breakdowns, and tell us in the comments which case should get dissected next. And for those who crave sharper, classier storytelling, stay tuned, because the truth, no matter how buried, always finds its way back into the light.